All right, so for today, and actually for the next couple of days, we are going to be looking at civil law and dispute resolution. This is going to essentially be covering several chapters, and we will be covering all of civil law in this one particular recording here. So we will be also be making some various stops along the way, but it is fairly sizable in its content. So let's get started. To begin, with civil law, we have a lot of actual definitions. The first is tort. Now, tort is an old French word that essentially means wrong, and tort law basically protects a variety of injuries and provides remedies for them. When we're looking at civil law, the key definition or difference between civil law and criminal law is that under the criminal law or criminal code, you are criminally responsible for your actions, whereas in civil law, you are civilly liable for your actions. Civil law essentially is the individual, whereas criminal law is the collective society. Now, under tort law, wrong, an injured party can bring a civil lawsuit to seek compensation for wrongdoing against a party or the person's property. And generally speaking, civil action is the least serious matters, and those are generally dealt with in the provincial small claims courts. As we've sort of referred to in the previous topics, there are quite a few different courts and structures in the legal system in Canada. But with civil action, cases that deal with large sums of money will go to the Supreme Court. However, there are many stages to civil action. This chart actually kind of shows you the different stages of civil action from a formal appeal, and judicial phase. Ultimately, you don't really need to know the intricate details of this for this course, but it is still wise and beneficial that you are aware of it nonetheless. Now, continuing along what is a tort, tort damages are monetary damages that are brought and are sought from the offending party. And tort damages are intended to compensate the injury party or any type of injury that was sustained as a result of whatever action that had been done. With civil courts, however, civil courts are there to determine which court will have the case. And there are, as I just mentioned before, many different kinds of courts. There is the ultimate court, which is the Supreme Court of Canada, and that court, as you see next slide, I'll explain more about that. But there's also the Federal Court of Appeal of Canada. There is the Federal Court of Canada, the Trial Division, Supreme Court of any province or territory, like Supreme Court of British Columbia or Supreme Court of Alberta. And then there are the various small claims courts that get mixed in. Now, as I mentioned before, the Supreme Court of Canada is the highest court in the country. It is located in Ottawa, Ontario, being the capital. And the Supreme Court of Canada, anyone who has a case there, parties must get permission to file an appeal at this level. And the Supreme Court is the highest level of court, which makes this court's decision legally binding not for the party or the individual, but for the entire country. Essentially, when it comes to like the power and like chain of command, the Supreme Court of Canada is pretty much at the top of the entire power structure of our country. You can easily argue that the Supreme Court of Canada is more powerful than the Prime Minister or the Governor General, anyone that is part of the executive or the legislative branch of the government system. Because the Supreme Court of Canada's decisions will become binding for the entire country. And thus, the cases that actually are heard in the Supreme Court, once they make the application for it, most cases actually are denied by the Supreme Court. They don't actually have to give a reason why it's denied, just they say no. But the few cases that actually are heard at the Supreme Court, you have about 9 judges that will listen to the case. There is no juries that are involved in the Supreme Court of Canada. It is completely binding. Now, with the Federal Court of Canada, the Appeal Division is where appeals that deal with matters that could impact the entire country is heard. Appeal means the person's basically lost the case and they're trying to have it overturned for whatever reason. Now, with the Federal Court of Canada, the Appeal Division, they will try civil cases that involved the federal government, Ottawa, and they will listen to cases such as copyright infringement, trademark infringement claims, citizenship appeals, and federal income tax, i.e., the CRA, the Canada Revenue Agency. The CRA, as this little commentary, has definitely been augmented and has been given a lot more powers in recent years. Now, the superior courts of provinces and territories, or appeal divisions, this will listen to appeal cases. Cases are heard by a panel of 3 judges, and decisions can be forwarded all the way up to the Supreme Court of Canada if it's warranted or not for it. And then the Supreme Courts or provinces and territories, these cases will deal with large amounts of money, at least a minimum of about $100,000. You always will have a lawyer in the superior court. Trials are heard by judge and the jury, and cases that can be heard at the superior courts are class action lawsuits, contract disagreements, and matters of serious personal injury. What has been common here, you might have heard of the news, is in British Columbia example would be ICBC, the insurance corporation for drivers, and how they were losing tremendous amounts of money in the courts because of injuries. And that has, according to the government, led to the decision of implementing the no fault system. Now, with the provincial small claims courts, this tends to be the fastest. You see in the image here, this is the small claims court in Surrey, a site where I would often take my students to as a field trip on the regular times. But the small claims are the fastest, they are the cheapest. Parties don't always have to have a lawyer to represent themselves, and usually small claims, the financial limit is about $25,000. There's lots of different kinds of small claims courts, which you'll be reading about. Now, all this can lead up from the different courts, and tort leads up to the remedies. And you can see there actually are a lot of different kinds of remedies. I just put it on the slide here so you get to see what they are going to be up, because each one of these terms is going to be in the upcoming slides. But essentially, we're going to be looking at pecuniary, non-pecuniary damages, special damages, punitive damages, nominal damages, specific damages, injunctions, examination of a judgment, debitor, garnishment, seizure, motor vehicle liability insurance, no-fault motor vehicle insurance, workers' compensation, and criminal injuries compensation. So let's dive into some vocab. Starting off with pecuniary damages. Pecuniary damages is a financial settlement that has been calculated, i.e. the example would be the no-fault uh, rates being implemented by ICBC. But non-pecuniary damages is a form of compensation for losses that do not directly involve an actual loss of money there. But it can have some sort of monetary value, but no money is actually being awarded or given over in the court supervision. Needless to say, this becomes very, very hard to prove there because, well, dollars and cents and numbers is a lot more straightforward. Special damages can be used to reimburse money from lost wages. Special damages are awarded to pay off debt that is owing for items such as drugs, therapies, and even ambulance services. One thing people sometimes will forget is that in British Columbia, even if you have like a care card, um, calling an ambulance, that is usually not covered by the public health plan. So an ambulance visit usually will start around $80. Punitive damages are financial compensation for the plaintiff. And punitive, as it means the word punitive, punishing, meant to punish the defendant for their action there, but punish him through a financial fine. Once again, if we use the driving example, these are the fines: speeding tickets, parking infractions, things of that matter. Nominal damages does not include any financial. Is kind of meant to be, as a word implies, nominal, a moral victory. You won, and just the sake that you won the case, that is more than enough for the individual. Specific damages is a court-issued contract that requires the party to pay a full specific terms of the contract. Injunctions is a court issue order that prohibits a specific action, such as no visitation, no see young people, curfew, maybe suspension of license. There's a lot of injunctions. No visitation can be another one. No cell phone. No internet access. It's there's quite a bit of variety that can be done with injunctions. An examination of a judgment debtor happens when the defendant refuses to pay, and then the debtor will essentially examine forcibly the debtor's entire defendant's entire financial status, all their stuff that basically is associated with the bank or the CRA, the Canada Revenue Agency, income tax, everything, bank accounts, personal property, stocks, owing money, property like houses or cars, boats, computers, everything. That's what it basically means there. And it'll examine what if the defendant refuses to pay, what they all have, and then the court will forcibly take it. Now, forcibly taking is garnishment. Garnishment is when the court orders a third party to pay the plaintiff for the money that is owed to defendant. Garnishment can be done if a person has a loss, like credit card debt or like a repo of a vehicle, or rent is not being paid. Like this is contract. This is civil matters. And this or garbage can also be a form on salaries or pay scales. This is something that gets put onto the person's account, and then if you any companies or public service that has like HR, they don't ask questions. They just put in deduction or whatever the code is onto that person's salary or honorarium or payment. Now, seizure is the last resort, and this is when an order is signed by the sheriff to seize the assets to be sold off, to set off a claim, basically seize control. You might have heard this. Sometimes you'll see like court-issued sale or court injunctions. This is a seizing of that property. Motor vehicle liability is meant to cover people who have been injured by a car. Not all people, even though it's illegal, will buy insurance. If you don't have insurance, you get into a car accident, you are in a lot of trouble. And this is meant to fill in that hole when people, for whatever reason, don't do it. There's no fault motor vehicle insurance, which is a different kind of fund to cover Canadians who don't have money to pay for the legal startup costs for like class action lawsuit that involves a vehicle. And then there's worker compensation, Works ABC, another fund to compensate workers who are injured on the job for it. And then criminal injuries is when applying to compensate victims for damages that have injured when the culprit does not have the financial assets. Okay, that's the first part. Second, we now get into torts. Now, if you recall, torts, of course, means wrong, and there are three different types of torts: intentional, unintentional, the negligence, and strict liability. Now, intentional torts is a category of torts that requires that a defendant possess the intent to do the act that caused the plaintiff's injury. And with intentional torts, there is two types: intentional tort against a person, and then the intentional tort against the property of a person. Now, intentional tort against is a law that protects a person from unauthorized touching, restraint, and or other kind of contact. The law also protects a person's reputation and privacy. And if there are violations of these rights, These are considered to be actionable as torts. And these are some examples of some actionable torts. First is intentional is assault. Assault is a threat of immediate harm of offensive conduct or any action that arouses reasonable apprehension of immediate harm. The actual physical contact is not always unnecessary, but um, as you see in the cartoon, is just a threat of it or possessing something with the intent to cause harm can be viewed as an assault. Battery is an unauthorized, harmful, or offensive physical contact with another person. Actual physical contact doesn't always have to be required. It can to be battery. It can also be unnecessary. But the difference between battery and you see with assault, right? Assault is the threat of immediate harm or offensive contact, which makes a person feel that they might be in danger, which is battery is the unauthorized harm or offensive contact to the person. So it can be a little hard to see the difference, but there is still a sizable difference to it. Now, false imprisonment is when the intentional confinement or restraint of another person without authority, justification, or without that person's consent. There's false imprisonment that does have a variation to it called the Merchant Protection Statute, which will essentially allow shop owners, business owners to stop, detain, investigate suspected shoplifters without being liable for false imprisonment there. But this Merchant Protection Statute can only be done if there is reasonable grounds for suspicion, suspects are detained for only a reasonable amount of time, and investigations are conducted in a reasonable manner. One thing you might have noticed a lot more is CCTV, right? Closed circuit TVs. That's one way that businesses, especially like grocery stores, will use to their advantage. Now, defamation of character is when false statements are made by one person about another. The plaintiff must prove to create defamation that the defendant had made an untrue statement of fact about the plaintiff, and the statement was intentionally meant to be harmful. Now, with a defamation, there are two types. There is slander and there is libel. Now, slander is just oral, so verbally speaking of it, and then libel is a false statement that appears in a letter, newspaper, magazine, book, photo, videos, social media, even so. Slander is the verbal, libel is essentially the written, and the written can be in any types of form. Now we're going to look at this case study, so I'll just pause here for a moment and then move on. Intentional torts against a person. There's also the misappropriation of the right to publicity, which is one attempt made by the person to appropriate a living person's name. Essentially, this is identity theft, also known as tort of appropriation. There is invasion of the right of privacy, the tort that constitutes a violation of a person's right to live her life without being subjected to unwanted publicity, so like social media. Intentional infliction of emotional distress. That's a tort when a person whose extreme outrageous conduct intentionally recklessly causes severe emotional distress to another person. This is called the tort of outrage. This usually will require psychiatric assessments. Intentional property, real property, and personal property. Real property is basically land, anything that's permanently attached, like a building, whereas personal property is like cars, books, clothing, pets, furniture, the refrigerator, content. It's like essentially real property is something that is like attached to the building, and the building is attached to the ground. And then the personal property is anything that is inside of it. It's like a certain point to say, like in a real estate purchase, if you have like furniture, paintings, stuff like that, that's considered to be personal property. But if you, I don't know, spend a lot of money on, for whatever reason, buying like a thousands of dollars of like security cameras from like Amazon, those cameras are technically screwed into the wall. These are the Blink XT2, I think. Technically speaking, that because of the fact that it's actually screwed into the wall, that can be considered to be part of the real property, the real estate. So if the person who's selling the property wants to actually keep those cameras, then they actually have to negotiate that into the actual purchase of the or the selling of the property. Those cameras either go with the buyer or goes with the seller. And then there's of course the trespassing. Trespassing to over personal property. Usually people have the signs that say persecution, close your cameras, beware of dog. There's a conversion of personal property, which is a tort that provides a true owner of the use and enjoyment of their personal property. Basically, no, taking over someone else's property, no. Then you have the unintentional torts, which is negligence. The oops. Now, unintentional tort negligence is a doctrine that says a person is liable for harm that is foreseeable consequence for their actions. Negligence is an omission to something which is meant to be done by a reasonable person. Essentially, negligence, there is a cycle to establish it. Now, the cycle of negligence, there is 3 stages to it. The first stage of cycle negligence is the duty of care. The duty of care had not been provided. Because of the duty of care not being provided, some sort of a breach occurred and some sort of an injury, personal injury. Like someone built a deck and they had like a house party, and the deck was only made, I don't know, like 2x4s, but they had like 30 people on the deck. Well, there is a breach of care because the owner of that property didn't monitor the situation. Then, by not monitoring the situation, too many people were on the deck. The 2x4s broke, which caused a breach, and then damages because people fell down and breaking deck. It's kind of like that. That is the cycle of negligence. Now, for negligence, to be successful in a negligence lawsuit, the Crown must prove first that the defendant owed a duty of care to the plaintiff, the defendant breached the duty of care, the plaintiff suffered an injury, and then the defendant's negligent act caused the plaintiff's injury. It's that cycle, that 4-stage cycle to it. But with negligence, there is a duty of care, which is what the courts will apply what a reasonable person may or may not do, or a reasonable professional standard. The breach of duty is a failure to exercise the care or act in a reasonable way. The injury to the plaintiff is the actual personal injury and or damage to that person or their property. They have to establish the cause, so the person who commits a negligent act is not liable or not. So actual cause or legal cause, causation in fact, are proximate for it, but the actual causation is the actual cause of the negligence, whereas the proximate cause is a legal cause. Under law, a negligent party is not always necessarily liable for the damages set in motion by the negligent act, but the law establishes a point along the damage chain which the negligent party is no longer legally responsible for the actions. It's quite a bit, but we're going to look at this case study right now to um, get a better idea about negligence. So I guess they should have kept the windows closed, right? Anyways, also with the negligence, there's the negligent infliction of emotional distress, there's the professional malpractice, and then the last big set is the special negligence doctrines. How someone can defend against negligence. A lot of times when people are defending against negligence, one way to get around it is to have a signed waiver, especially when it comes to assumption of risk. You're going to go skydiving, you're going to sign up some paperwork saying that you are aware of the risks of this activity. Few things now to wrap up. There is business torts, which is for certain businesses and professions without a license. For business torts, there's disparagement, there's false advertising, there's misrepresentation, so essentially fraud. For business torts, elements are required to find fraud is the wrongdoer made a false representation about the fact. The wrongdoer had knowledge that the representation was false and intended to receive and deceived the innocent party. Innocent party was justly relied on the misrepresentation, and the party was injured. Fraud, it's basically is lying in the business sense. In business torts, is intentional interference with contractual relations, a breach of it. With business torts, there are punitive damages, but are not always recoverable for that breach of contract, but recoverable for certain conduct, such as fraud, intentional conduct, or other egregious conducts. And then we have strict liability, which is liability without fault. A participant in covered activity will be held liable for any injuries caused by the activity, even if she was not or he not actually negligent in it. But for strict liability, the doctrine essentially holds that there are certain activities that can place the public at risk of injury even if reasonable care is taken. And by doing that, the public should have some means of compensation if an injury occurs. And that is torts and our start into civil law.